the UK left the EU, everyone who was an EU citizen and wished to remain in the UK had to apply for the EU settlement scheme and get one of two statuses. If at the time of Brexit, which was December 31st, 2020, you've lived in the UK for 5 years or more, you were granted a settled status, which is also called an indefinite leave to remain, and which allows you to live and work in the UK indefinitely, meaning forever, as long as you keep to some residency requirements. If you haven't lived in the UK for 5 years on Brexit Day, however, you were granted a pre-settled status, also known as limited leave to remain. With this, you were given the right to live and work in the United Kingdom for a period of 5 years, after which point you were required to reapply for a settled status, and as long as you could prove your 5 years of residence, you were given the settled status, otherwise your rights to live and work expired. The pre-settled status of millions of EU nationals and their family members, which was granted around the time the EU settlement scheme opened in August 2018, is due to expire in the second half of 2023. In a recent development though, the UK is about to change its position. The High Court of England on 21st December 2022 ruled that the EU settlement scheme was unlawful and in contradiction to the withdrawal agreement between the UK and the EU. The judge determined that even though the UK was able to implement a system requiring individuals to apply for an immigration status by a specific deadline, the withdrawal agreement only requires one application for resident status to be made where the host state has adopted a constitutive system. The justice ruled that applicants granted pre-settled status should not lose their rights of residence if they do not make an application for settled status. This was on the basis that the wording of Article 13/4 of the withdrawal agreement makes it clear that the right of residence can only be lost in very specific circumstances. The expiry of a status was not among them. Since the ruling, the government has confirmed that there will be no appeal, which means it has already become law. To clarify, this ruling will have two very important consequences for pre-settled status holders. First of which is, pre-settled status holders can be required by the government to reapply for a second time to get settled status, and the other one, the more significant for most, is that pre-settled status no longer expires after 5 years. The Home Office hasn't put out an official guidance reflecting the change yet, but a government spokesperson signaled that it should be made public before the first pre-settled statuses are set to expire, which means July or early August. It's unclear at this time how those changes are going to play out, but seeing the ruling, the government doesn't have many options. The way I see it, they could either give settled status to everyone automatically or remove the need for one altogether. It remains to be seen which approach they choose. Removing the expiry date from pre-settled statuses doesn't mean you can't lose your status at all, however. Rights can still be revoked or lost if you remain outside the UK for over 2 years, or if you get caught submitting fraudulent applications, so be aware of that. Otherwise, it's really good news for pre-settled status holders, because you can stop worrying about absences in case you can't prove your residence for any reason, or you happen to be absent over the allowed maximum period. So, overall, it's a really big move in the right direction. Thank you for hearing me out. See you next time.